The reason ACID started was because every time I brought a new product out, it was ripped off. And I felt absolutely helpless because there was nothing I could do. So from a roundtable action group in 1996, here we are today with 1,200 member companies, and also we're now a sort of serious UK design campaigner. So what I'd like to whistle through today are some of the basics of IP law. I don't know the levels of knowledge about IP law, but I hope I'll make it user-friendly. I'm not a lawyer, so I've done it in a way that I hope that I can understand it. So if I can understand it, you can understand it. Design protection, some of the decisions you may be faced with. What to do if you're copied. There's a trend now to use social media to deal with copying complaints, a sort of fast track to action. We've also introduced the first UK Designs Exchange, ACID Marketplace, so I'd like to share those ideas with you too, and run through just one or two guidelines on what I consider to be necessary for an effective IP strategy. And lastly, the culmination of 15 years' work, the IP Bill, and what it actually means. We cover a variety of different sectors within the industry, and looking at the guest list today, I see that we also cover contract furnishing, fabrics, wallpapers. So our membership reflects about 24 different industry sectors. What do we do? Well, we've championed right from the word go, 1996, design protection, its enforcement, and we have worked really on behalf of our members on a lot of issues about design law reform. The most important thing is about fighting IP theft and safeguarding innovation to ensure that tomorrow's growth creators can live in a safer trading environment with job certainty. Most of all, we want to communicate that original design equals value, and there have been hundreds of settlements on behalf of ACID members and over 300 mediations. One of our main aims is to see that in the same way that there has been sustainability and green issues in corporate social responsibility, that respect, ethics and compliance are a communicated must-have within corporate social responsibility. And those are in our next talks with the Minister for Intellectual Property to see if we can roll this out across the industry. Design, as we all know, is around us, from design icons that you can see here to every day, solving our problems, adding value and enriching our lives as customers and consumers. As Sebastian Conran says, without creativity there's no culture, and without design there is chaos. I don't know if you would agree with that. But the most important thing is that the latest creative industries figures point to a staggering £8 million every single hour from the creative industries. And design is certainly a key part of that, with £35.5 billion per year. And it's growing at 10% per year. So what we have deduced from that is design is a key differentiator in an ever competing marketplace. Underpinning all this is intellectual capital, which is really a critical asset. It's the DNA running through most of our businesses, whether they're micro or macro. And most successful organisations are underpinned by intangible assets. The most important thing about these key assets is that if they are valued, they can be leveraged as a recognisable, unique selling point for key drivers in, say, mergers, acquisitions, investment, or even used in exit strategies. And so, like any other property right, intellectual property can be traded, it can be sold, it can be licensed, it can be used in knowledge transfer, and it's very much a tradable asset. So, the very basic elements. I use the analogy of a house. I talked before about property rights, and the principles that apply to property law apply to intellectual property law. There are two, and as we know, the generic term is really for patents, trademarks, design right, copyright. There are two different types of right: registered rights that you pay for, patents, trademarks and designs, and unregistered rights that arise automatically. Copyright, unregistered design rights, unregistered trademarks, intellectual capital, know-how, ideas, confidentiality. and you don't pay for these. One thing that's in common is that owners must give permission for their use in the same way as with your home or flat. It's a property right. So in the same way you can lease your property, sell it, sublet it, rent it, share it, but you certainly don't want squatters. So copyright and overview. What does it protect? Well, anything that's 2D, if we look at any engineering or technical manuals that you may have, architectural plans, design drawings and plans, paintings, sculptures, photographs, promotional literature. In a lot of lookalike cases that we've had, people have copied word for word people's ads or their marketing material. But you do have copyright in the marketing material that you produce. Your computer software, your databases, they're all protected by copyright. I think it's important to point out what it doesn't protect. It doesn't protect ideas, it doesn't protect concepts or inventions. It doesn't protect ideas because you have to express these in a 2D or 3D way before they're protectable. And copyright lasts anything from 25 years to the life of the originator plus 70. This is just a very quick example of a case that was taken to the what was then the Patent County Court using evidence that I supplied. It was a company that produced this image which is used on various products, and it was taken by New English Teas. The fact that it was put on our design data bank meant that we were able to give a genesis of its audit trail. And we have about 300,000 designs on our ACID design data bank, which is one of the free benefits of membership. In terms of design right, you can have UK design or EU design. And according to the Office for Harmonisation in the Internal Market, which is a very long name for the European registration body, these are the criteria that are necessary for a design. So it could be the lines, colour, shape, texture, contours, materials or ornamentation. So if I was putting this for to get a registered right, I could protect its shape if it was original, I could protect the surface decoration, I could protect the texture if it had a texture, and also the colour. The good news about a registered design is it's a monopoly right. It's like having a piece of paper, a certificate, which says that you own a design. And it means that it lasts for 25 years and cover in 28 member states. I think it's 28 at the moment, isn't it? This is just an example going way back of, you probably recognise these stools that have been ripped off all over the place. But in fact, Magis did own the original rights, and they had registered UK, EU rights. They also relied on unregistered rights. And now we have a new right. The UK is just about to accede to the Hague Agreement, which means that with one single application, you can cover about 62 different countries. And that's soon going to include the United States as well. Moving on to, well, that was just my other job with, happened at an exhibition where knockoffs were discovered, letter before action was sent. There was a delivery of lookalikes. We couldn't do anything with them because they were unsound. The mechanics of the hydraulics were unsound, and the actual material that they were made of were unsound. So we destroyed thousands. That particular story hit the headlines globally, and it enabled them to communicate a zero tolerance of IP theft. The benefits of a registered design is that it, for protection, it allows you to stop others from copying your designs without permission. It also contributes to your preventative and deterrent strategies. And it allows you to sell the design and all the intellectual property rights or license the design. So in other words, it is a tangible IP asset that can be put on the bottom line. Moving on to trademarks, we've been amazed at the number of companies who still haven't registered their trademarks. And I think it's probably, I consider, one of the most important rights because it's really everything we stand for, whether you're trading under a single name or your own name. Again, the registered community trademark covers 28 member states, and there is something called the Madrid Protocol, which has agreements with various different countries all over the world that the UK is a signatory of. Interestingly here, our trademark's been copied several times. People want to use the acid trademark. It's been copied many times in China to, I guess, get a certain amount of respectability. So we've done everything we can to protect what sits under our own brand. Benefits of a trademark are obviously protection against competitors using your name, protection of businesses being accused of infringing another mark, reassurance, valuing your IP asset, and also maximising business opportunities. And I suppose having that registration means peace of mind. Interestingly, the oldest registered trademark is the Bass sign, which was registered first in 1875. And lastly, patents. Frederick Mostart describes it very well here in that a patent essentially protects an invention, typically new or improved products or processes in the field of science or technology. Patent protection generally covers functional or technical features of these products and processes. Dyson certainly is a real supporter of patents. He uses them globally to protect his designs. I think the thing about patents is that they are extremely expensive to get, and they're also reasonably expensive to enforce. So a patent route is not a short-term route, but is a very strong right. So the reality of taking action. You discover what appears to be a copy of something you've created. And I guess the next thing is to say, well, am I going to take action or not? One of the things that we always say, which I have to say I was guilty of in years of yore when my products were consistently ripped off, was I sued on principle because I felt so passionate that somebody could steal what I'd created. And it really wasn't the best idea at all. So through the years I learnt that I had to actually say, well, is there going to be a demonstrable loss? And if so, then it is obviously worth protecting. It helps if you've got a UK or community design because it's effectively a certificate that says that you own the design. As Trevor Bayliss, the inventor, says, nobody's going to pay you for an idea, but they might pay you for a piece of paper which says that you've got an idea. With both registered and unregistered right, with registered rights you don't have to prove copying because you've got a piece of paper that says that you own that right. With unregistered right, you need to provide a genesis or audit trail, and that's where our Asset Design Data Bank comes in very handy. Our members can get a free legal opinion, but a lot of lawyers will also give initial free advice. One of the things that the IP bill, when it's passed, is going to offer people is an opinion service, and that will cost £200 per opinion. There's quite a bit of controversy about this because people say, well, it is an opinion. Do you want a legal opinion or do you want the IPO opinion? My experience to date is that we've actually probably taught the IPO an awful lot about design because they up until the last 5 years, had very much ignored design really as a recognisable right. It was always considered a Cinderella right. Moving on to the difference between unregistered and registered rights, I would say that the majority of our hundreds and hundreds of cases have been based on unregistered rights. And taking legal action isn't about going all the way to court. It's actually saying, well, this is a journey. And so often, a simple letter before action that explains exactly about what you're complaining, evidence to prove what you're complaining about, can achieve a result. So, I've gone into the various sort of things to think about. You may or may not know that there has been a new small claims track introduced. Prior to telling you about that, we've talked about the quantifiable loss, and really it's about identifying what you want to achieve. Is it an undertaking that further copy products won't be sold? Do you want damages to reflect quantifiable loss? Is it a public admission of liability? Is it about protecting your market share? Is it about payment of your costs? And I think we've always advised that there are so many solicitors out there with sectoral experience within fabrics, within furnishings, within furniture, who are looking at a sort of long-term and commercially led solution. So I think the most important thing is to ask whether what you're trying to prove is realistic and reasonable. The small claims track will assist claimants wanting to sue with disputes under £10,000. So certainly for micro businesses and SMEs, this is a really valuable new initiative. And it was one of our campaigning objectives that we achieved in 2004. We've also tried to put recommendations to make the court process a lot more simple. And I'm glad to say that under the auspices of a very inspired judge who's since been elevated to higher places, over the last 2 years, in the Intellectual Property Court, which has been renamed, it used to be the Patent County Court, but that we didn't feel reflected the whole vast range of intellectual property rights. It has reduced costs, it has improved access to justice, and it's brought the UK in line with other European courts such as Germany, which I don't know if you have experience of German courts, but it's a much quicker and more effective process. And the aim is for it to be cheaper, speedier and easier, and also much more informal than the High Court. They're introducing an awful lot more mediation. I mentioned earlier about the social media. Quite a few companies now, and especially small companies, are resorting to social media to do the sort of, spot the difference when they discover a copy. You may have seen this in the headlines. It was Tattoo Divine, who a really original jewellery company, found Claire's accessories producing, very, very similar lookalikes. They decided to go viral, and they achieved a very, very speedy result. Within 24 hours, Claire's accessories removed the alleged copy from the site. There's 2 watch points here. Number one, in UK law, there is a thing called groundless threats. So if I accuse you of copying me, and in the end it proves that you haven't, then you could actually sue me. So it's a really serious thing in this country, so it's important to get the right sort of advice, and the right advice is either from your own trade organisation or somebody like ACID if you are going to go down that route. And there's also the issue of defamation. One has to be very careful what goes into the social media arena for those very reasons. So those are the watch points there. I was delighted that in December, the Minister for Intellectual Property and government as a whole endorsed the first UK Designs Exchange. And that's something that we have evolved from our design data bank, which I mentioned earlier holds over 300,000 designs. The whole point was to try and create a safer online trading platform. And that was to allow design buyers and designers to put their new designs on our data bank, and for design buyers to register once and to sign the ACID Buyers Charter that they comply to our corporate social responsibility expectations. And the options are open to our members so that they can either keep the designs confidential as they have always done, they can invite people to view the designs, or they can be open on Marketplace. And the whole thing is to provide this benefits to ACID members. At the moment it's ACID members only, but we're talking to government to make this available to the whole of the UK. And I'm really excited about that because it's a means by which there can be a safer exchange. And also that we hope that we will build up a really strong list of those buyers who are prepared to sign in, support British design, support British manufacturers, and look at the really value British design in a very positive way. I'll run through very briefly the basic elements of an IP strategy. Anybody who would like me to sort of send our full list later would do so with pleasure, but the headline points are, number one, if you haven't got one, create one. And it's about positive communication. This is all practical aspects. It doesn't require an awful lot of expense. It's actually communication, internally and externally. On your website, terms and conditions, marketing material, product labelling. And it sends a clear message about IP and value. And as we all know, it's best to have a plan in place so that it's not firefighting. It's best to have an IP plan in place so that we aren't firefighting you know, in the case of IP theft. Prevention is better than the cure. We have a very simple statement that a lot of our members use on their websites, which just communicates that they own the intellectual property rights and any infringement will be taken very seriously. This is a statement that's available in about 25 different languages, so it certainly can hit home to maybe countries that are not so respectful of intellectual property rights. It doesn't take much to become IP savvy. I'm not a lawyer. I've become IP savvy by necessity as a product designer and interior designer, and by what I do now, trying to advise business. Choose battles carefully. What do I want to achieve? We've gone through about never suing on principle and always getting expert opinion. And publicising settlements, it sends a clear message about a proactive IP strategy. An IP portfolio, is as I mentioned earlier, is a very good portfolio to have in terms of access to funding for selling one's business exit strategies, and also for investment. Our design data bank is free. It provides an audit trail, an accessible record of designs, independent proof of date of creation. It supports the deterrent effect, and it's underpinned by the ACID brand. I think you're all probably aware about trade secrets, but it's really important to have those sort of restrictions put in terms and conditions of employment. Confidentiality, I think we all have different levels of confidentiality within our businesses. It's important to recognise these and make sure that there are safeguards. I can't emphasise the strength of having agreements. Not having agreements makes lawyers extremely rich, so it's very useful to be able to rely on the small print when you actually need it. I'm in negotiations at the moment with IP insurance, and we're also in negotiations to try and persuade government to make this available on a national basis, which would make it affordable. I'm a great believer in mediation. I honestly believe it's good to talk. So many times I've asked our member to pick up the phone to people that they've got a problem with, and so often it has proved to be positive. We all work in very similar markets, and if litigation can be avoided at all costs, I think it's a good strategy. To finalise that, I think it's being aware, watch competitors slowly, if you have to find legal advice, find legal advice where there are solution-led proposals, commercial-led objectives, and a long-term relationship with an IP lawyer does save time and money long-term. Lastly, 2 slides, I think, about the IP bill. There are 4 key issues that it will affect designers. It has been made clear and established that the designer will now own the IP rights for commissioned work, not the commissioner. I mentioned earlier the opinion service. The UK will also agree to the accede to the Hague Agreement, so that means broadening the number of countries, and I think it's 62, with one single application for design registration. I think most controversial of all, there will be criminal provisions for intentional registered design infringement. We tried for unregistered design rights, but government wasn't listening hard enough this time. The majority of UK designers rely on unregistered rights, and we feel that this is the next stage in our campaigning. On the left, you can see a songwriter, on the right, a furniture maker. Up until now, there's been a complete disparity in that the songwriter can rely on criminal provisions if their songs are stolen. A furniture maker, a furniture designer couldn't. The whole point about this is to reduce the scale of registered design infringement by acting as a real strong deterrent, to increase the protection for those who invested in registered designs, and to punish perpetrators of blatant design infringement. And our 2 ACID surveys showed that 97% and 87% thought that design infringement was blatant. Thank you very much indeed, everybody. I'll just finish with one plug for the Furniture Makers Company, of which I'm very, very proud to be a liveryman. The Furniture Makers Company is the British Furnishings charity and patron, and it supports the education of students by nurturing skills and expertise, it provides help to those in need, and it champions excellence. This year I come in as the chair of the Communications Committee, and my role over the next 4 years will be to get that message to the North and the South and the East and the West, that there is a resource there and a fund there to help people with our industry who fall onto hard times. And I'd ask you all, if you are thinking about it, do speak to me or to Colin. It is a fantastic organisation to belong to. Thank you.